Welcome to Small Practice Support Information Session number 53. In this Law Society of Ireland recording, Richard Grogan talks to Justin Purcell about returning to the workplace.
So you're all very welcome to Returning to the Workplace, Tips and Traps, more traps than you think. And I'm here with Richard Grogan. Richard, you're very welcome today to come and join us. And you're all very, very welcome to the call. So if anybody wants to ask a question of Richard, we'll take it via the chat. So over to you, Richard. Richard, what's happening at the moment? Because it seems kind of like Trina Kayla, as they would say. It's coming and going and nobody's quite sure with regards to return to work protocols.
All right, well, we got out the return to work protocol from the government, and it was announced with great fanfare that this is how it was going to operate, Justin. And what we were told was you were going to be able to work out or ask when everybody had been offered vaccination, were you vaccinated or not? You would be doing a health and safety assessment as to whether you could have vaccinated and not, or non-vaccinated people in the workplace. If you couldn't have a non-vaccinated person in the workplace for health and safety purposes, then you were going to look at remote working or redeployment. Now, by the way, it didn't deal with what happened if you couldn't have them remote working, you couldn't redeploy them. The government kind of stopped at that issue, but probably went to dismissal. So that's what we all thought we were going to be doing, and we'd be turning around and saying to people, well, if you're vaccinated, you can walk around as much as you like, and if you're not vaccinated, you're going to be wearing a mask. Now, there was a few GDPR issues raised over that. You know, one person said to me, would it be possible to give people green and red hats so that you'd know who was vaccinated and wasn't? And we said that wouldn't probably be acceptable. So that was fine. We were all going to be moving from there. And then the Data Protection Commission, let forward a torpedo and just blew the return to protocol completely out of the water, because the Data Protection Commission turned around and said, you can't ask anybody whether they were vaccinated. Now, they said you can't even try and do it in a roundabout way, like saying, that was very good for me. How was it for you as regards your vaccination? You couldn't do that. You couldn't even do it that way. So they said that there was no health and safety issue, that you couldn't have vaccinated and unvaccinated people in the workplace side by side. So we were back now then to, oh hell, we're back to the 2 meters, what we have at the present time. And that doesn't work in an awful lot of offices. And definitely we're back to the issue of wearing masks as you walk around offices, and the whole issue that we have there. So that was where we were. Then we had the government come out with this idea, for example, restaurants, that you could have everybody in who was vaccinated. And that's going through at the moment. And the one thing in the background is what happens with the waiting staff. Because they're supposed to keep 2 meters apart from each other. And if anybody's been into a restaurant, even the outdoor restaurants recently, the staff aren't 2 meters apart, they're not even 1 meter apart. But there's a slight technical problem. They have to keep 1 meter apart from the vaccinated people once they go back, if they're not vaccinated. So how do you give somebody their steak and put it on the table? If you have to stay 1 meter apart, you put it on the floor, you stand up and collect your own steak, or do you get off the table and move back so that the waiting staff can put everything on the table? So we're really into a whole issue as to how is this going to work? In reality, I want to be honest with you, Justin, in reality, employers are going to need to know if people are vaccinated or not. If they don't know whether they're vaccinated or not, we have a couple of problems. One, it means that you have to presume nobody has vaccination. It means then that if you have an employee who has a disability and turns around and says, well, look, hold on a moment, I've got an underlying health issue. I really should only be working with people who are vaccinated because I've got a problem. You can't find out as to where you can put them safely in the workplace, unless you put them in a room on their own and they're sort of isolated from everybody. So the whole issue has become a complete nightmare as to how you actually do it. Now, what's happening is people are taking their own, look, we'll do it this way and we'll hope for the best. And that's just going to open up a litigation nightmare, because effectively, if somebody comes in and says, hi, I've got an underlying issue, I've got a problem coming back, unless I'm working with vaccinated people, and somebody says, well, you're all right, the floor that you're on, everybody's vaccinated. The employer has now disclosed the vaccination status, medical history, effectively, which is sensitive information, of every single employee on that floor. You now have the employer facing a GDPR tsunami of claims if the employees there want to bring claims. So some employees brought back to the workplace, turns around and says, hold on a moment, this has been disclosed. I really want to work from home. Now I can head up to Richard Grogan and I can bring a data protection complaint to the Circuit Court. Not to the Data Protection Commission, to the Circuit Court.
Yeah. So that's a lot more complicated. So is the return to work protocol that the government have issued, is that where my safe haven is? Is that where I should go to find out the facts of the matter in what is a very uncertain situation?
No, it's been blown out of the water because everything that's in it is working effectively on the presumption that you're going to be asking people what their vaccination status is come September. So really, the protocol is, if I would put it this way, the protocol is defective in that you cannot ask anything relating to the vaccination status, which basically undermines the whole basis of the protocol in how you get people back into the workplace. So it's dead, like a dodo.
And so what should I do now as an employer?
Well, as an employer now, really what you have to do is you are now in a situation that you can't ask. So you now must presume that nobody has been vaccinated. And even when everybody's been offered vaccination, and even if you've been told privately that everybody's vaccinated, you have to still operate on the basis that nobody's operated, because you can't let anybody else know that everybody's vaccinated, because then you're going to be disclosing sensitive medical information relating to every employee. Now, you can ask for consent, which means you have to, but the issue in asking consent has been blown out by the Data Protection Commission also, because they say, as an employer, you're in a dominant position, and therefore that's an inappropriate question to ask in itself, even to ask for the consent to do it. So you're into nobody's vaccinated and everybody's 2 meters apart, even if everybody's been offered vaccination and they've told you that they've been vaccinated. That's the problem.
And which is more important in this situation? Is it the health and safety, or is it GDPR? Which trumps which?
Health and safety trumps GDPR, but the only way health and safety trumps GDPR is if the medical officer and the HSA turn around and say that there's a health and safety issue, that people must know what the vaccination status is. So if NPHET come out and say, look, an employer can only have vaccinated people in the workplace, that's fine. That trumps GDPR. If they turn around and they say you have to segregate vaccinated and non-vaccinated, that's fine. That trumps GDPR. But it's not just NPHET that have to say it. You actually have to get the Health and Safety Authority, because the way that it works in this country, if I can put it this way, the government and NPHET cover everything up to walking in the front door of the office. The HSA covers whatever happens inside the office. So you have to get both of those online, otherwise the GDPR trumps. So if NPHET say you have to have this, but the HSA don't, then in those circumstances, once you walk in the door and the questions are asked, you've got a GDPR problem. So this is a real one where the problem we have is we don't have an overriding body that gets all the different groups together, and then they come out with an agreed statement. What we have is disparate groups doing their own thing and not being related to each other. So it's a real problem. And this is a problem, it's not just for solicitors' offices, by the way. This is for accountants. This is for somebody down the road who's working in a shop. You know, this is going to be a real problem. If I take this as a simple example of a barber shop or a hairdresser that had 8 chairs in February 2020, the 2 meters apart means now that there may be 2 chairs less, which means 2 people lose their jobs. Now, the human rights lawyers would be turning around and jumping up and down with me for saying something like this, that people have a right to privacy and you can't stop anybody getting back to work because they don't want to be vaccinated or they don't want to be tested. And by the way, testing is a real problem as well, because NPHET doesn't like testing, nor does the Data Protection Commission, because you're retaining records about the testing. So there's a problem with that. But we're coming fairly close to a choice. And the choice is, do we just work on the basis that we don't ask the questions, or do we ask the questions? If we ask the questions, then there may be more jobs saved, but some people will lose their jobs. If we don't ask the question, then there's more people going to lose their jobs, because if I take the hairdressers, for example, everybody could be vaccinated, but instead of 8 chairs, there's only 6, 2 people have lost their job. If one person won't answer, or doesn't want to answer, or they can't be asked, or they turn around and say, I don't want to be vaccinated. So you could have, so it's one job as opposed to two jobs. These are the questions that are going to come up.
And what about practitioners saying, well, we're an essential service? Does this not allow us some preferential treatment or changed status?
Yeah, well, I always love that. That's great. Jesus, we're an essential service. We have to. Sure. I get this all the time. I'm an employment lawyer. I had a firm tell me one day that did I not understand how a firm that deals with international clients deals with as regards the Organisation of Working Time Act, and surely the Act didn't apply to solicitors. Sure, no legislation applies to solicitors. So we should be allowed, build our offices wherever we like. Preserve buildings. I will knock that wall out, and we'll put in, get rid of those old windows. We'll put in nice PVC. No, an essential service does not mean that you don't apply health and safety legislation, and much to the chagrin of some practitioners who believe that no legislation that they don't like doesn't apply to them. But no, because we're an essential service doesn't mean that we can disregard the stuff. That's like saying that an ambulance service doesn't need to bother making sure that the vehicle is safe because it's an essential service. If it ends up crashing, but we didn't do the checks on it. No, sorry, that doesn't wear.
So then what are some bottom line employer responsibilities in this situation? What for both practitioners and then for practitioners giving advice to their clients?
All right. First thing is you need to do a health and safety assessment. That's for your own particular building. So if that's health and safety as regards entry to the building. So that covers everything from hand washing to face masks and sanitization of workstations, cleaning, how it's going to be done, moving around the office. All of that has to be done. You then have to work out who can come back. So if you're in an open plan office, you're going to have less people back. If you're in an old office like I am, and all the solicitors have their own room, then that's fine. The solicitors are back because they're more than 2 meters apart. If you have solicitors sharing a room, then you've got a problem. Can you keep everybody 2 meters apart? Where you've got, we say, an area where you've more than one person working, then the issue is, can you keep them 2 meters apart? Can you put up the appropriate screens? Have you got the appropriate tests in place for people coming in? By the way, if you're going to take somebody's temperature, that Data Protection Commission absolutely happy with you taking the temperature, provided you don't record the temperature. So if you have one that is, that all you have is that there's some of these temperature ones which go green and red. Green is fine, red, go home. That's fine because it's green and red. But if you have to have somebody take the temperature and record that they're 34.2, then you've got a GDPR problem. So if you're recording any information, you need to have this set out in a health and safety assessment as to why it needs to be recorded, who has access to it, how long it's going to be retained for, making sure that if it's retained for, we say 3-4 days, that you're getting rid of it. You've got to do the same then for people coming into the workplace. So if you've got clients coming in, you really need to have them fill out, and we have it, you fill out a questionnaire and it's sent back. Have you had COVID in the last 14 days? Have you traveled abroad in the last 14 days? You really have to do all of those things. You've got a problem, by the way, asking any staff member, have they been on holidays? Because all they now have to tell you is that it's safe for them to return. So unless they're on a red list country where they have to be, where the government meets them at the airport and puts them in a hotel, if they're the ones where they have supposed to stay at home for 10 days, if the employee turns around and says, no, it's absolutely fine, and they walk into the workplace and it's been raining for the last 2 weeks, and they say, well, you've lovely tan, and you must have been abroad. Well, you've got a problem there asking that question, because the answer on it is you can no longer ask it. Maybe the clouds parted in Kerry for the 2 weeks. That's how they got the great tan. So it doesn't matter. You can't do it. So that's a real problem. So the issue that you have to say to employers is, whoever you're going to do, you're going to be turning around and saying, that's the issue that's coming up, and you have to be really careful on what questions you ask. I see a question coming up there. Why can't you ask about holidays? Very simple. The Data Protection Commission says you can't. End of story. You want to ask about it? Welcome to the Circuit Court. You know, the issue then comes about legal obligation for protection to people. No, you can't ask without the medical officer and the HSA saying that you have to ask questions about vaccination. The answer on it is you can't ask the question, and you presume nobody has it, and you keep everybody 2 meters apart. That's it. So you try opening up a business and everybody 2 meters apart. It's not going to happen. So whatever you've been working at in, you know, April or May, and presuming that you've all been fully compliant with HSA guidelines, health guidelines, and the rest, that's how you're going to be working until there is a direction that you can ask about vaccination. Now, by the way, once you do that, you then have to take into account issues of disability. That's an, you know, somebody turns around that. And by the way, you're going to have the one also is, I don't like wearing masks. You can, in that circumstance, ask for evidence that they have a disability that means they can't wear a mask. So there's a huge number of issues that are coming along there.
So what about, Richard, reluctant returners then, just on this issue of people obstructing or not being in agreement is probably a better way of saying it. So reluctant returners or non-vaccinated staff, how do we treat them?
Well, there's going to be the person who says, I'm not happy to come back unless everybody's vaccinated. Well, you can't answer that question. But that's the answer to it. The reluctant returner, yeah, these cases have actually, the WRC is backlogged with stuff, but the cases in the UK are going, the reluctant returner has been in the UK, and in one case, the person was dismissed on the basis that they couldn't work from home. It wasn't realistic that they work from home. The employer offered them unpaid leave. They didn't like that. And the employer said, no, you can't work from home. It's not feasible. So the person who says, I want to work from home, well, at the moment, they have no right to work from home. Their contract will have an address. You either come to work, you don't come to work. You don't come to work, you don't get paid. That's it. Now, when it comes in a right to request, well, that's going to take a year for the WRC to deal with that. In the meantime, you either come to work or you don't get paid. The reluctant returner is going to cause as many problems. If you say, well, look, Joe is really slow and wanted to come back to work, so I'm going to let him work partly from home. But then you're going to have Mary who turns around and says, well, I'm doing the same type of work as him, and I want to work from home as well. And you go, well, you can't have both of you out. So you're going to end up, you have to be very careful how you do that you don't walk into an equality claim. Or you don't walk into a constructive dismissal claim. So there's going to be a lot of reluctant returners who say, I can work perfectly well from home. The answer on that is, the evidence is at the moment is that, yes, the productivity was similar prior to COVID and as of now, but that evidence is also coming through that that's because people are working longer hours. So employers have to be very careful. If you're going to have people working from home, you have to do a health and safety assessment for their home workstation. Who pays for it? By the way, 1,500, $2,000 to set them up properly at home if they're blended working. And by the way, a laptop isn't sufficient. You have to have a lot more than a laptop. And a laptop on its own, by the way, is another health and safety problem, because you have to have a separate console and screen. So that's one of the problems there. The reluctant returners, yeah, there's going to be lots of litigation over that. And the other one is going to be not so much the reluctant returner, but the person who wants to come back. It says, my contract says that I work from 9 Harbour Place. Well, I'm not happy to work from home. I want to come in. Well, we can't have you in 5 days a week. Well, that's your problem. I'm available. If you want to send me home, you can send me home, but I'm not working from home. So that technically is the position. The employee says, right, well, I'm coming in. Well, we can't have you in. Well, good luck. Pay for me. I'll be in for 3 days a week. Yeah. Well,
so there are implications around these sort of hybrid models that are being, or remote working that are being proposed.
The problem on it is that we don't have any joined up thinking. The employment lawyers, the health and safety lawyers, the GDPR lawyers, the human rights lawyers, the medical profession, and the health and safety authority are not all being put in a room to come up with a plan that actually works. And by the way, you need to bring in business people in there as well. You could have ISME, you could have IBEC, and you could have the ICTU. as to how, leaving their hats outside the door, how we actually open up workplaces. And at the present time, what I can say to you is what I would have said 3 weeks ago, I wouldn't have said when we recorded this, because I wasn't going to be here today, last week, and it wouldn't be what I'm saying today. So this thing is changing on a daily basis. And if you're advising a client, you've got to say to the client, what I'm going to tell you today, I might be changing next week, and you need to give me a phone call because it could all have changed. That's not fair to businesses. And, they have the thing then is, do I think that NPHET and the HSA will issue something about vaccination? Well, what I can tell you is NPHET will not say anything about antigen testing, or that you can use that as an alternative. They don't like antigen testing. So will they do it? I don't know. I think probably NPHET will probably, once everybody has been offered vaccination, I think you're going to get NPHET turn around, and the way they're operating at the moment, probably turn around and say, no jab, no job. You're not getting back in. The question then is, will the government capitulate to that or not? But that, I think, is what they will do. Then the issue is, will the HSA run along with it? Because NPHET can just stop them going into the workplace. The HSA has to then set out the rules as to how you actually get into the workplace. And if the NPHET simply say it, the question then is that enough to trump GDPR? It's a real kind of problematical area that needs to be actually addressed. But I think NPHET will say, no jab, no job.
Wow. So there's a query there from confused why a data breach is going to the Circuit Court, not the Data Commissioner.
Because you can go to the Circuit Court. So if an employee is bringing a claim, to go to the DPC, it takes ages, and they don't get they will rarely get compensation for it. If you go to the Circuit Court, you can get compensation, but you can also, as part of the claim, look for a declaration from the employer that your data protection rights have been breached. And that's done effectively in open court. That's a declaration. So it puts an awful lot of pressure on an employer because the compensation awarded to the employees actually is not huge, but you've now got an employer with an admitted or a found against data protection breach. Doesn't do their good name an awful lot of good, and also they're staring down the barrel of a full set of Circuit Court proceedings costs, not only to defend it, but for the solicitor and barrister appearing on behalf of the disgruntled employee who is there to vindicate their GDPR rights as a working man or woman, which they're entitled to do. They won't get much compensation, but it's surprising when you've got a set of Circuit Court proceedings what negotiations might go on, as you sometimes turn around and say, when you're seeing the hangman's rope of a set of Circuit Court action against you, you might be more amenable to a proposal by their solicitor to a compromise.
So Richard, we're coming up to 23 minutes past. We've just got a couple more minutes. Do you want to you were going to give us a little bit of an update on the Workplace Commission?
All right, the legislation is going through. They're going to get it sorted out so that we can have hearings. They've only sorted out part of it, and one of the because you will be able to have sworn here evidence, you will be in public, and they've dealt with the independence of the adjudicators. The issue that hasn't been brought up and is going to start coming up is that now that it is the, quote, administration of justice, close quotes, the old decisions which say, I find in favour of the employee and I award X as being just and reasonable, that's gone. Now they're going to have to set out the reasons why they've set that amount. And it will mean that individuals, if they don't get that set out, can put their appeal into the Labour Court, ask for a hold and go for a judicial review against the WRC to get the reasons so that they can work out whether they should or should not appeal the case to the Labour Court. And they'll be entitled to that. So you can see some employers particularly will use that for the purposes of delaying, and equally you'll get some employees who will use it as a method of, well, I want to know why I was only awarded 30,000 as an unfair dismissal case. They say I contributed, my loss was 100,000. How did they make it out of 30? I'm entitled to know that. So, you know, you're going to see an awful lot more litigation. Take it that the WRC is also going to see a tsunami of litigation, not coming down to them, they'll get that anyway, but actually against them when people start challenging it. So it's going to be an interesting time to be an employment solicitor.
Very good. And we're just coming to the final end. So if anybody wants to ask a final question of Richard, we'll take it now. And if you just want to quickly summarize what you think the main pertinent points are, and maybe just, you were talking about the Gender Equality Diversity Charter as well. You were going to.
Oh yeah, well look, I mean, I want to mention JEDI, as we call it. It's a very good thing to sign up to. It actually, it's not that hard to comply with. It really just means treating people properly and rightly. And I'd encourage every office to sign up to the charter. It's a very good message to give to yourself. If you're a principal, it's a very good message to give to everybody in the organization. And that's from the cleaning person right up to the senior partner. Everybody is involved in it. Everybody has a right to that respect. And I think what we saw in the papers yesterday about one of our colleagues when she went to a prison and been asked to do certain things, it indicates the importance of us as a profession dealing with it correctly.
So I've just shared my screen there with regards to our future upcoming sessions. So we've just 2 more sessions in July: Managing Legal Accounts Regulations by Pat McCosker and the Benefits of e-Signature by DocuSign. So Richard, you've been great sport to join us today. I don't think there's any more questions. If there's another question on the chat, we'll take it. What's the name of the charter? So it's the JEDI.
Yeah, Gender Equality, Diversity and Inclusion Charter. If you get onto the Law Society, you can sign up. And if you sign up, they give you a nice little charter that you can sign. And they also then give you a nice little logo that you can put on your website to show everybody that you have signed up to it. So it's a good thing to do, and you get it, and it's a great way of promoting it. So I'd ask everybody in your firm, whether you're a principal or you're an associate solicitor, would you go and make sure that we get all the firms signed up, so that the Law Society have a list of them at the moment. What we want to have a situation is that they turn around and say, we're not putting up the list because everybody's on the list. So I'd ask you to sign up to that. It's a good thing for us to be doing, and it shows you, if you're in a solicitor's office, you should be signed up to it anyway, because you should be doing it anyway, because it's simply complying with the law.
So Richard, just a final remark there from Helen. You're extremely thought-provoking, but scary. Any final comments?
Yeah, well, the way this practice works is that when we do employment law, we're very decent and very reasonable. What we do is we show the other side the instruments of terror, and then we give them an opportunity to buy us off that we won't use them on them. Look, I don't mean to scare anybody. The reality on it is that I'm scared of this, because the advice that I'm giving today is going to be different than the advice I'm going to give next week. If I'm back next week, I'd be saying something different. So it is scary, but you need to read the legislation. You need to read the guides. You need to read the GDPR regulations. You need to read the health and safety guidelines. And you just need to know this stuff, because if you get it wrong, it's a litigation nightmare. And I want to say to people, don't just take a run at it and hope for the best. You know, that's a bit like jumping over a wall and then finding there's a cliff on the other side. You need to look over the wall before you jump over it to make sure you're doing it right. And I don't mean to scare anybody. And by the way, if any colleague needs a heads up or needs some help on it, my mobile number is in the law directory, and they pick up the phone and they give me a phone call, and I'll help them out as best I can. I don't claim to be an expert. Some people call me an expert. I just claim to be a specialist. Specialists are people who don't know everything, but we'll find out. But I can find out where the answer is if I need to. So if somebody needs help, give me a shout.
Listen, Richard, thank you very much for your time today and your unique insights into this evolving situation. So thank you very much, everyone, for joining us today. Hopefully you'll join us next week with Pat McCosker. Thanks to Richard, Slán agus Gur Malgut, and hopefully we'll all see you again next week.
Take care. Thanks.
Take care. Bye.